Our topic now is ethics and the ethics rules. And it's important to realize that there are some ethical dimensions to the way that you handle e-discovery disputes. There are 5 rules that we need to make our way through in order to be able to understand what it is that the Code of Professional Responsibility demands of you as you're working through these e-discovery disputes. The first thing is, obviously, to think about your competence. Are you competent to be able to handle this case in the light of the fact that there is electronic discovery? It's important to realize that that competence issue is something that the lawyers argue about and worry about, and it can be that you are going to dedicate yourself to be educated so that you educate yourself on the law and the procedure of e-discovery so that in fact you become competent. But of course, to the extent that you are not competent, then what you're looking for is either an ability to get assistance from somebody else, or what you're looking for is a decision that's got to be made. You know, I'm in over my head here. We really need to get somebody else brought in to handle the e-discovery pieces. A lawyer shall provide competent representation to a client. Competent representation requires legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation. Remember that Zubilake here says that we as lawyers have got to be competent. We cannot claim, well, I don't know how this stuff works, if we're offering representation, and if what we do is we say, well, I don't know about the electronic discovery issues, and so I have no idea whether or not in fact we've produced what we're supposed to produce. Obviously that's not going to make it, and Zubilake makes that clear. Now, rule number 2 is important to look at. Rule number 2 is 1.2 is the rule that talks about your authority between you and your client about who controls what as this litigation gets going. And a lawyer, as you remember in 1.2a, shall abide by a client's decisions concerning the objectives of the representation, and as required by Rule 1.4, shall consult with the client as to the means by which they are to be pursued. This second part here then is important when you're talking about what it is that you're going to do in the way of producing discovery to your opponent. And obviously here you want to be careful that you describe to the client these means and get them to recognize that what goes around comes around, so that the more that they're cooperating, the more that presumably they can demand cooperation from the other side and limit the costs about what it is that's going to be done. Now, recognize that this last sentence, a lawyer may take such action on behalf of the client as is impliedly authorized to carry out the representation, gives the lawyer then a fair amount of discretion as to finally how the e-discovery issues are going to be handled. What I'd like to do next is now to talk about 1.4 and make sure that you see that 1.4 is crucial to how it is that you are to handle the communication issues with the client. The lawyer, remember 1.4 says, shall promptly inform the client of any decision or circumstance with respect to which the client's informed consent is required by these rules. Reasonably consult with the client about the means by which the client's objectives are to be accomplished. Now, how do you do this with an e-discovery matter? Well, I'd suggest to you that to the extent that you can, that you provide the client with a written outline of the electronic discovery steps. That, of course, we've broken it down in the past, and you can outline this quite easily. We have the preservation issues, we have the privilege issues, we have issues about cost shifting, and obviously we've got production issues that we can go through as you're managing your electronic discovery databases. And so when you're thinking about these steps, outline for the client, then what would be, you expect a timeline for the way that electronic discovery is going to be produced. And the affirmative obligations that have to be exchanged between the parties, where you have to exchange all relevant information to the claims and defenses, and that the other side is expected to give you the information that they have on their side of it, and that you give a timeline in writing as to what it is you expect to happen. Of course, you should obviously explain to the client that these things are going to change depending on what we find. And remember that we talked about earlier in our discussions about how you need to be paranoid, that in fact your timeline ahead of time could get you into some serious trouble as you're thinking about whether or not, in fact, you really can easily find all the backup tapes. One of the things to do is to do your own searching and then to go ahead and say, you know, well, the timeline that we've had, it was based upon what it is that we thought was going to be the systems, and as we've looked ourselves through the various data, we found new things. And don't be too worried about then that your expectations as laid out in your written plan are going to be varied. You know, every general knows that the battle is much different often once it's engaged than what it is that you planned before you got in there. And so you want to make sure that you are giving notice as much as you can, and then as you go along, when new things come up, you want to take the time to make sure that you consult with the client about the need for the change. So you have written advice, you will have oral advice as you go through it, as you're giving suggestions to the client as to what it is that they need to do and agree to about coming off from preservation issues, what it is that you're going to do in order to be able to manage and preserve all of your privilege issues. And then obviously, as you hit the production side, you start to think about the cost shifting. You're going to have oral advice that will handle those issues also. Let me say that if you're going to convey clearly to the client the caveats of your advice, so that as you give advice as you go, obviously you're talking about risk. And when you talk about risk, it's important to realize that the client, to just say, well, there are lots of risks in doing it that way, I recommend against it, that's not very helpful. There's risk in anything you do. You want to be able to describe the risks as compared to what. And what you're looking at is either some kind of percentage risk, some kind of probability, high probability, low probability, the kind of the most likely scenario, the least likely scenario, in order to be able to give the client some realistic idea of what it is you mean when you say that there's risk in the particular advice that you're given. So let's talk about 3.1. 3.1 conditions us all and cautions us all about not bringing or defending a proceeding or assert or controverting an issue unless there is a basis in law and fact for doing so that is not frivolous. Here we have this one-sided burden that our obligations to the justice system not to bring frivolous cases recommend our hard advice to our client about whether or not a position that they're taking passes the smell test, whether or not, in fact, based upon what it is that you've been able to discover, whether or not, in fact, you have an obligation to, in turning over that information, recommend to the client that they take a settlement posture. And you know, the more that you dig deep into your client's records, the more that you may discover that, in fact, there's a problem. And obviously, then that presents a nice ethical issue for you, because on the other hand, the whole adversarial system expects a competitive discovery process, that the other side doesn't get something unless they ask for it. And so what you have then is this nice little ethical dilemma between not taking a position when you know that it's frivolous, and on the other hand, that you do not need to turn over things to the other side unless they ask for it or the rules demand you to do it. And obviously that's that nice little piece in the new Federal Rules of Civil Procedure where there is an obligation to turn over things that are relevant to claims pled and defenses in the case. And so what you have then is a very nice counseling session with the client about what it is that you found and what it is that is the client's obligations about what they need to turn over and how that affects whether or not they proceed to litigation or whether or not there's discovery or whether there's settlement of the case that's going to be recommended. You need to have a basis in fact for your position. That means you must have competently investigated the facts before you argue one way or the other on preservation or production issues. Now, 3.4 does say that there's a fairness obligation to the opposing party, and that, of course, what you're not going to be doing is unlawfully obstructing another party's access to evidence or unlawfully altering, destroying, or concealing a document or other material having potentially evidentiary matter. So client says, I know what we can do with this. We can take these files, we can change the names, and we can hide them off into another section. Obviously, the ethics rules prohibit that. You may not take and conceal, destroy, or unlawfully obstruct the discovery exchange that the other side is entitled to. A lawyer shall not counsel or assist another person to do such act. It's not enough for you to say, well, I didn't know what was going on, the client did it. Obviously, your obligations in fairness to counsel are to be aware of what the client's doing, and if you, in fact, find this out, there's obviously going to have to be a come to Jesus meeting with the client to be able to ensure that that behavior is going to stop and that the information gets turned over. Recognize the 3.4 in pretrial procedure, make a frivolous discovery request or fail to make a reasonably diligent effort to comply. That fail to make a reasonably diligent effort to comply is something that's been heightened by the Zuber Lake opinion, and in fact in some opinions that follow, that the court says, look, you have the Morgan Stanley case is a major one, you have a specific obligation to take reasonably diligent efforts to ensure that the client has complied with the discovery request. And so if counsel certifies that the discovery has been conducted and that the search has gone, that certification places the lawyer into a dilemma. First, the lawyer needs to be competent to know whether or not, in fact, that certification was, in fact, done and is true. And without that competence to be able to ask the questions and determine what it is that's done, well, Morgan Stanley suggests that the law firm bears some risk in then certifying that the discovery has been done. And the lawyer then, in knowingly making false statements by certifying that something's been done, is informed by the level of competence that the lawyer needs to have in knowing whether something's been done. And similarly, it's important to realize that there is some diligence required by the lawyer to search the storerooms of the client to find out whether or not the tapes have been all gathered and whether or not, in fact, you've got compliance with the directions, the discovery directions that you've given to the client over a period of time. Candor to the tribunal is the last issue, and it's related to what we've been talking about. A lawyer shall not knowingly make a false statement of fact or law to a tribunal or fail to correct a false statement of material fact or law previously made to the tribunal. Again, these certifications are the trap for the unwary in these electronic discovery matters, because if you certify and then you later discover, you're put in an obligation of making sure that you inform the court. When these kinds of things happen, remember, confess your sins and confess them early. Don't try to make them go away or hope that you are not going to get caught. The Morgan Stanley case is a terrific example of lawyers and law firms that did not confess early enough, and the court held it against the law firm individually in terms of what it is that the law firm was required to do in excess of $1 billion, at least initially, and that spoliation issues against the client were also severe also. So recognize that the candor to the tribunal is a quick candor. It's as soon as you've discovered that there's been a false statement that's been made, and 3.3 makes that clear, that the failure to correct a false statement of material fact is something that the lawyer shall not knowingly do. Thank you.